So as I said earlier, today's session will take us through the core principle, practical applications and professional potential of ADR in the corporate and commercial ecosystem. To guide us through this insightful journey, we are joined by an esteemed panel of experts who bring a wealth of experience and vision in the field of dispute resolution. May I now invite our session coordinators, CS Venkataramana R, Council Member, the ICSI, CS Dwarkanath Chenur, Council Member, the ICSI, learned speakers, to kindly come forward and take their seats on the dais. I request CS Avneet Singh Arora, Director, Arbitration and Conciliation, Department of Legal Affairs, Government of India, Dr. Ashok Kumar Mishra, Government Nominee, the ICSI, and ex-technical member, NCLAT, CS Nisar Ahmed, former President, the ICSI, Advocate Iram Mazid, Executive Director, Asia Pacific Center for Arbitration and Mediation, and Mr. Chirag Balyan, Assistant Professor of Law, Maharashtra, NLU, to join us on the dais. We welcome all our dignitaries. Kindly put your hands together for this wonderful session and for the dignitaries. Let us all tune in with curiosity and open minds as we explore how ADR is not just a method, but a mindset that reflects the future of fair, fast, and forward-looking justice. We are honored to have a panel of highly accomplished experts in the domain. I now request CS Venkataraman R to please welcome CS Avneet Singh Arora, Director, Arbitration and Conciliation, Department of Legal Affairs, by presenting a planter. A huge round of applause, ladies and gentlemen. CS Avneet Arora presently works as Director with the Department of Legal Affairs, Ministry of Law and Justice, Government of India at New Delhi. I now request CS Dwarkanath to please welcome Dr. Ashok Kumar Mishra, Government Nominee, the ICSI, ex-technical member, NCLAT, by presenting a planter. We welcome you, sir. Sir is a distinguished fellow of IICA, Government Nominee in the Governing Council of the ICSI, Independent Director of ICAI, Registered Valuers Organization, and Professor of Practice, Law and Finance at Jamia Hamdard, New Delhi. We welcome you, sir. I now request CS Manish Gupta ji to please come on the dais and welcome CS Nisar Ahmed, former President, the ICSI, by presenting a planter. Sir is the former President of ICSI for the year 2012. He was a member of the Central Council of ICSI from January 2004 to January 2015. We welcome you, sir. I now request CS Ashish Karodia ji, please join us on the dais to welcome Advocate Iram Mazid, Executive Director, Asia Pacific Center for Arbitration and Mediation, by presenting a planter. Ma'am is a distinguished legal professional with over 21 years of experience, making her a prominent figure in the field of arbitration and mediation. We welcome you, ma'am. I now request CS Dr. Mohit Shaw to please join us on the dais to welcome Mr. Chirag Balyan, Assistant Professor of Law, Maharashtra National Law University, by presenting a planter. We welcome you, Mr. Chirag. Mr. Chirag is an Assistant Professor of NLU, Mumbai. His teaching assignments focus on subjects like ADR, international arbitration, mediation, research methodology, and legal methods. We are privileged to have you here amongst us today. To introduce the sub-theme and set the context of today's discussion, we have with us distinguished professional, a thought leader in his own right, CS Venkataramana R, the council member and the session coordinator. So may I invite sir to take us through the panel discussions. Stage is yours, sir. Yeah.
Very good morning, members present over here and also present through online virtual mode. Ladies and gentlemen, very good morning to you all. Friends, on this session I would like to mention that the alternate dispute resolution mechanism has opened a wider doors for the company secretaries as a corporate professionals, both in employment and also both in practice, to take up this role as an arbitrator at the commercial arbitration issues, either in India or outside India. Friends, in the age where the time of essence stakes are high, the need of swift for the effective dispute resolution is most important, and the traditional and conventional method of dispute resolution often falls short in terms of the speed and effectiveness because of the load made on the courts. If you see the epics from the Indian epics like Ramayana and Mahabharata, we also seen experienced that where the mediation fails, the war begins. As a professionals, we are here to help the corporate sectors taking forward the arbitration proceedings. As a professionals, we are also committed for upholding the principal corporate governance, and we recognize the disputes are inherent as a part of the company's operations. In the competitive landscape, the companies for the market share and profitability and inevitably gives rises of various conflicts and disputes. There are many contracts which even doesn't provide arbitration clauses in the agreements. So as a corporate professionals, we need to guide the corporates how the arbitration clauses to be drafted and how the arbitration proceedings to be implemented in the corporate commercial disputes. The timely and just resolution of commercial disputes is not only crucial for minimizing the disruptions and also legal expenses, but also for vital of overall health of our economy. Efficient dispute resolution methods prevent prolonged conflicts and foster and quicker outcomes and preserve the business relationships, enhance the business effectiveness. Friends, ADR has came in year 2019, and where the Institute of Company Secretaries has taken many initiatives in 2019. The ICSI CCGRT, as a convener of ICSI CCGRT Hyderabad, I am proud to inform that more than 1200 company secretaries were trained in the arbitration training programs, and it has conducted professional training and programs on commercial arbitration. The program was divided into basic and advanced simulation programs. And ICSI also offers a post-membership qualification course on the arbitration to its members to provide career guidance and practical assignments of the arbitration, and also appointment of arbitrator agreement, how to conduct the proceedings, how to take the evidences, etc. Friends, ICSI also has the first introduced it as an elective paper for the students of professional examination group 1, the subject on the arbitration, and the first international arbitration ADR center was mooted by this council in the year 2023 under the leadership of CS Manish Gupta ji, and during the presidentship of Narsimhan sir in 2024, the ADR center was inaugurated by past Justice P. Sadasivam sir, former Chief Justice of India, and now in the year 2025 under the leadership of Dhananjay Shukla ji, the 30th January 2025, we have also got the ICSI International ADR Center Commercial Arbitration Rules 2025. With this, the arbitration proceedings will be held and conducted in the ADR Center of ICSI at Noida. And this is a great moment for us to have such an arbitration center as a basic initiative to promote the arbitration in India. Friend, with this brief note, now I will leave the session to the speakers, panelists. Thank you very much. Thank you one and all. Now I request CS Avneet Singh Arora sir, Director, Arbitration and Conciliation, Department of Legal Affairs, Government of India, to take the session forward.
A very very warm good morning to all and all present. At the outset, I would like to thank the Institute of Company Secretaries of India, of which I am also a member, for inviting me here. It is a pleasure to see that the Institute is giving great focus to the alternative dispute resolution mechanisms, and it is evident that a specified section has been allocated to discuss this very important mechanism. I would also welcome all my co-panelists. I think it's a very esteemed panel that we have together. We have representation from the practitioners side. We have some veteran professionals from the institution. We have Mishra sir, who has been a part of the government for a long time. We have academician Chirag also here, and so I think we'll have an interesting discourse going ahead. To understand what ADR means, I think the context has been set by C.S. Venkatramana ji. Alternative dispute resolution is something which is alternative to courts. So the idea is to have a support function or a system which allows parties to get their disputes adjudicated in a private manner by subject to consent of parties. So whether it is arbitration or mediation, it is all consent driven. So party autonomy is what governs arbitration and mediation, because we understand that the rule of law requires disputing parties to go to court. But by consent and by contract, the parties can agree that rather than going to court, they would want their disputes to be adjudicated either through arbitration, where there is adjudication, or by mediation, which is more amicable settlement by facilitation by a mediator. So the arbitration regime is governed by the Arbitration and Conciliation Act of 1996. And the mediation regime presently is governed by the Mediation Act of 2023. Although mediation also finds reference in various enactments which have been passed earlier. Section 89 of the Code of Civil Procedure of 1908 also provides for mediation. And the second part to the Arbitration and Conciliation Act provides for conciliation to be adopted. So the focus of the Government of India has always been to ensure that the ecosystem for ADR mechanism is efficacious and efficient. And to that extent, there have been policy and legislative interventions that have been taken over a period of time. As far as the Arbitration Act is concerned, it was enacted in the year of 1996. It has gone 3 major amendments in 2015, 19, and 2021. Because arbitration is in the nature of being a private adjudication mechanism, there are broad checks and balances which are required to be kept in mind when arbitration is done. So therefore, pre-2015, for example, a major initiative was taken wherein, because we understand, I think we are all professionals, that arbitrator is expected to be impartial and independent. But pre-2015, there was no statutory provision to ensure that the arbitrators who are appointed by the parties are independent or impartial. There were various occasions where the employees of the parties in dispute were also appointed as arbitrators, which is in the teeth of the broad premise of principles of natural justice that nobody should be a judge in its own cause. So therefore, in 2015, a provision was added which ensured that the arbitrator who is expected to be appointed for a dispute between the parties does not have any relationship with either of the parties. So this was a major change that happened in 2015. Apart from that, in 2015, the process has also been made more time-bound. So there is a time which has been provided under the Act. The arbitration is required to be completed in a period of 1 year, which is extendable to 6 months. So the focus of the arbitration amendments in 2015 was to ensure that the process becomes more efficacious. That apart, there was also one major criticism of arbitration, that in case an arbitral award is passed in a dispute between parties and it is challenged before court, there was an automatic stay. So therefore, the award was not enforceable under law. That also underwent a change in 2015. In 2019, the focus has been on institutional arbitration. There were some amendments made to encourage institutional arbitration, जिसको हम संस्थागत arbitration भी कह सकते हैं, जिसका example अभी C.S. वेंकटरमना जी भी दिया कि ICSI ने भी अपना एक ADR का international center setup किया हुआ है नोएडा में. I think it's a step in the right direction, and it is important that the practicing company secretaries also adopt arbitration as a profession going forward, both as being arbitrators or being arguing people in the disputes before arbitrators. उसके बाद 2021 में एक छोटी अमेंडमेंट हुई थी, और अब हम लोग 2024-25 में भी हमने एक ड्राफ्ट प्रपोजल प्रपोज किया हुआ है. It was put up for public consultation also. So let us see how it goes forward from there on. This was as far as arbitration is concerned. कमिंग टू मीडिएशन, जैसा हमने कहा है सेक्शन 89 ऑफ सीपीसी मीडिएशन के को भी इनकरेज करने का स्टैट्यूटरी प्रोविजन बताता है। 2023 में हमने मीडिएशन एक्ट 2023 पास करवाया, जिसमें द फोकस हैज़ बीन टू इंस्टीट्यूशनलाइज मीडिएशन similar to what is done for arbitration, where arbitral institutions are more recognized. We have also tried and make a mediation also an institutionalized mechanism. So there are various stakeholders which have been recognized. There is a mediation service provider which is recognized. There is a mediation institute for giving training to mediators which has been recognized, and a mediation council of India which is expected to be a quasi-regulator for mediation. So the broad framework of mediation under the Mediation Act is to ensure that it is done in a more formal manner, which is what was missing prior to the Act of 2023. Conciliation, जो कि एक similar principle है alternative dispute resolution का, that was more informal. उसके लिए कोई संस्थागत mechanism हमने Act में, हमारे जो पुराना Act था Arbitration Act का जिसका part था, उसमें नहीं दे रखा था. तो अब जैसे ही Mediation Act पूरा enforce हो जाएगा, the part which is conciliation of the Act of 1996 will get subsumed into the Mediation Act of 2023. That apart, we also in the Department of Legal Affairs also administer the Commercial Courts Act of 2015. उसमें भी एक specific provision है section 12A की, जिसमें यदि आपको किसी भी commercial dispute से related court में कोई suit file करना है, तो you are required to compulsorily attempt mediation at the first instance, and only then a suit can be filed in a commercial dispute. This provision was added in the year of 2018. Again, the idea is to encourage parties to settle the matter rather than going for adjudication either before the court or the arbitrators. So the focus has been to ensure that the statutory provisions of governing these mechanisms and enactments, that is the arbitration and the mediation, are up to the mark. They are globally benchmarked, and the parties are able to use these mechanisms to effectively resolve their disputes. इसके अलावा हमने एक और संस्था शुरू की है नेशनल इंपॉर्टेंस की, विच इज़ कॉल्ड द इंडिया इंटरनेशनल आर्बिट्रेशन सेंटर. वो भी एक इनैक्टमेंट था 2019 का, जिसके तहत इसको एस्टैब्लिश किया गया है. इसका रोल है आर्बिट्रेशन करवाना. जिस तरीके से वेंकटरमणा जी ने बताया कि ICSI ने एक ADR का सेंटर शुरू किया है, जिसके रूल्स भी 2025 में शायद पब्लिश हुए हैं. सो द आइडिया इज़ टू हैव दिस इंस्टीट्यूशन conduct arbitration as per the procedure in the rules. So it ensures that the criticism of ad hoc arbitration, जहाँ पे कि जैसे हम प्रोफेशनल्स हैं तो हम सुनते रहते होंगे कि आर्बिट्रेटर्स बहुत ज़्यादा समय लगाते हैं या फीस बहुत ज़्यादा लेते हैं, तो यदि अगर संस्थागत तरीके से आर्बिट्रेशन की जाए तो ये जो क्रिटिसिजम्स हैं ये एब्जॉल्व हो जाती हैं, बिकॉज एक संस्था जो होती है उस पूरे प्रोसेस को सुपरवाइज करती है टिल द पासिंग ऑफ द आर्बिट्रल अवार्ड. दैट अपार्ट संस्था के पास एक पैनल भी होता है आर्बिट्रेटर्स का, जो कि इज एक्सपेक्टेड टू बी वेल इक्विप्ड, एंड देयरफॉर द क्वालिटी ऑफ आर्बिट्रल अवार्ड इज ऑल्सो जनरली बेटर इन इंस्टीट्यूशनल आर्बिट्रेशन. So because the arbitration is as good as the arbitrator, so it is very, very important that the arbitrator is well equipped. So finally coming to this is the broad overview of the ADR mechanism statutorily in our country. Coming to the role of company secretaries, I think the company secretaries have a very, very important role when it comes to ADR. We all understand and appreciate that company secretaries are one of the few professions which have access to the higher management. So the idea to effectively convey the advantages of ADR mechanisms for effective dispute resolution to corporates or even for company secretaries in practice becomes very, very important. That apart, even as professionals, what the company secretaries, my fellow company secretaries, can look up to is being arbitrators and mediators. Because I think the major advantage with company secretaries is that we understand law, we are very good at drafting, we draft the decisions for the companies at the highest level through our board resolutions. So the healthy mix of understanding law and the capacity to draft, which can be very, very helpful when it comes to becoming an arbitrator and passing arbitral awards. So I think it's a very, very, very niche area where we are very well equipped. I think the only idea is to pick it up more. We were talking, I think सुबह भी हम लोग सुन रहे थे कि there is a lot of competition in the market. So we will have to look at new avenues. So company secretaries are very well equipped to be both arbitrators and mediators. And therefore I would humbly request that, जैसे वेंकटरमण जी बताया कि अगर हमने अपना सेंटर भी शुरू किया है, तो it should be the enhancement of skills of the members should be a continuing process, and we should also market the center to all the disputing parties, because there has been a consistent movement from ad hoc arbitrations to institutional arbitration. और यदि हमने ऐसी संस्था सेटअप कर ली है तो आर्बिट्रेशन एक्ट में भी और मीडिएशन एक्ट में भी दोनों में काफ़ी अच्छा स्कोप है टू इंश्योर दैट we are able to let the disputing parties have the fruits of the early resolution of disputes through these ADR mechanisms. So with these opening remarks, I will then leave the other parts to the fellow panelists. Thank you so much.
Thank you very much, sir, for setting the tone for the session. Company secretaries are really playing vital role in arbitration proceedings and mediation proceedings. In the arbitration appeals also, which are proposed now that are coming up, in that appeal proceedings also we need to develop some training mechanism where our company secretaries will be well equipped with the arbitration appellate proceedings also. Now I invite Dr. Ashok Kumar Mishra sir, government nominee, the ICSI and ex-technical member of National Company Law Appellate Tribunal to come forward and address the members.
Good morning, Mr. President. I think in absentia, Mr. BP, Mr. Ashish Mohan also in absentia, Mr. Manish Gupta, Mr. Narsimham, all past president, and my all colleagues this side. Mr. Nisar Ahmad, very learned man, they will tell you more things. Mr. Arora has explained you. Venkat Sahab is master in arbitration. Ma'am is well knowledgeable. So in the week, and Mr. my Bangalore colleague is much more learned man than me. So I can tell you I am the weakest link in this. Still with my experience, some experience, I can tell you. Let me tell you the strength of mediation. Dear friends, you can realize from IBC recovery of money. Post IBC, मतलब जब केस फाइल हो जाता है, after that, from those actions of the tribunal and the decisions of the tribunal, recovery from 2016-17 till 2024-25 is 3.89 lakh crore. Whereas through settlement means mediation, either it is a procedural mediation or a kind forced by the tribunals, sometimes, not always, recovery is 10.78 lakh crore, and 30,000 and odd cases have been sorted out through settlement, whereas through court proceedings, as my friend Mr. Venkat Raman and Mr. Arora has told you, the cases settled is only 1,194. I am remembering the exact figure as on March 25. So see, 30 times cases have been settled through mediation, and recovery, much more recovery, 4 times recovery has been made through settlement than fighting in the tribunal or through the forced provision of the insolvency and bankruptcy code. Since I have been told to speak about the arbitration and mediation in insolvency matters, and particularly the study of the countries like UK, USA, so being now a professor, my one student has deftly made an analysis. So based on that, I will speak something, but I can only given you a broad view what has happened in India. Let me tell you, even under UK insolvency law, mediation is not compulsory, because in the United Kingdom, there the courts are only actively encouraging the use of mediation. The Companies Act, that is UK Companies Act 2006 and Insolvency Act 1986 provide the statutory framework for insolvency procedures, while the Chancery Guide of 2016 further promotes the use of ADR, particularly mediation. While courts typically prefer to stay proceedings rather than order ADR, but the duration of such a stay is subject to the parties' consent. However, if a party unreasonably refuses to consider ADR, courts can direct them to take reasonable steps towards exploring it, which When I was in the bench, I have also done in NCLT Bangalore, even in NCLAT Delhi also. Now, if you go to the USA, the United States has been pioneer in adopting mediation, particularly in the context of insolvency resolution, although the Bankruptcy Reform Act of 1978 USA didn't explicitly promote the ADR as a preferred mechanism for insolvency. The Alternative Dispute Resolution Act of 1998 authorizes all district courts in USA to use ADR in civil action, including bankruptcy-related adversary proceedings. This law mandated that each district court offer at least one ADR method, such as mediation, early neutral evaluation, mini trial, or arbitration. By 2009, over half of the US Bankruptcy Code has formally adopted mediation through local rules or court orders. The Bankruptcy Code for the district wise also, each state has also got certain rules. The Bankruptcy Code for the Southern District of California had already introduced insolvency mediation in 1986, and since then mediation has become a prominent feature of the bankruptcy process. By 2019, 76 out of 94 districts, that is of the US, had implemented local mediation rules, with some courts mandating mediations, while others have adopted voluntary adoption. Under the ADR Act of 1998, each district court that uses ADR must maintain a qualified panel of neutrals, including judges, attorneys, or trained professionals. Mediators are required to meet rigorous training and experience standards, often requiring 20 to 40 hours of training, along with substantive mediation or legal experience. I can tell you, recently I was in one of the meeting in the IBBI, I was called, and there also I insisted that the insolvency professionals, their business are coming down because the NPA content has reduced in the market. So their business, at least large number of IPs business have come down. So it was suggested that you have to make the mediators only these insolvency professionals if you have to keep this profession. I can tell you today, because I have got the figure, I am involved in at least two of the IPAs, both CA and CS. I can tell you large number of insolvency professionals are not even enabled to pay their fees, and they are not interested in perhaps continuing. But the unfortunate part under IBC is once your registration gets cancelled, you have to go through the entire process. CA का मैं फीस पेमेंट नहीं करूँगा, मेरा नाम कट जाएगा, 5 साल बाद फीस देके, या CS में भी 5 साल बाद फीस देके रेगुलराइज हो जाएगा. वहाँ आपको पूरा एग्जाम देके सेम प्रोसेस से फिर इंसॉल्वेंसी प्रोफेशनल बनना होगा. So I also suggested, in both the institution I have suggested, जिसकी बिजनेस नहीं है उसका फीस मिनिमल करिए, जिसकी बिजनेस बहुत है उसका फीस बढ़ा दीजिए, लेकिन यंगस्टर को चलने दीजिए, उनके प्रोफेशनल एक्सपीरियंस एंड ग्रोथ का आप रिस्पेक्ट करिए. I don't know, but at least whatever little I have got the asserting powers, I have used it. Let me see how does it happen. Coming to the arbitration perspective in the UK and USA, it is usually believed that conflicts pertaining to the administration of insolvency procedures or those that arise from the implementation of insolvency law are normally not attributable. Once insolvency proceedings are initiated, the majority of insolvency legislation specifies that arbitration proceedings would be stayed. Generally, it is the law even the worldwide. The reasons behind postponing arbitration proceedings to give rise to the trustee or administrator. जैसे हम इंडिया में आपको इंसॉल्वेंसी प्रोफेशनल बोलते हैं, कंट्री वाइज इट इज नेम इज चेंजिंग. trustee or administrator, and same concept. Enough time to go over all the claims from creditors and evaluate the insolvency parties' financial situations. The stay of arbitration proceedings is typically temporary and lasts until fulfilling a specific requirement, such as, for instance, in Switzerland, following the second meeting of creditors. वहाँ system different है. And in Australia, upon the approval of winding up of companies. Certain matters considered not arbitrable. Certain insolvency matters are generally regarded as non-arbitrable, particularly those considered core insolvency issues. US का भी है, US में specific है. Chapter 11, such as the initiation of insolvency proceedings, appointment of trustees, or distribution of assets from the insolvent estates. Arbitration being a private, as my colleague has told, Mr. Arora and Mr. Venkat Ramnaji, arbitration being a private dispute resolution method focuses on adversarial settlement between parties, whereas core insolvency professionals aim to reorganize or liquidate assets for collective creditor benefit. The core / non-core distinction is particularly well developed in the US, where core matters arise solely under bankruptcy law, while Switzerland also applies the framework. Now, if you go by the UK legislation, they have not addressed the arbitrability of insolvency proceeding, and there is no rule on arbitrability under arbitration law. हमारा जो ये IBC है, this is based on mostly on UK law. Same provision there. A party's capacity to continue with arbitration is unaffected by insolvency according to legislation. There is a case law in Fulham Football Club Limited versus Charles. This is 2001 citation. So it is necessary to consider in relation to matters in dispute in each case whether they engage third party rights or represent an attempt to delegate to the arbitrators what is a matter of public interest which cannot be determined with the limitation of private contractual processes. Same case law, Fulham Football Club versus Richards and another 2011. EWCACIB is a citation number. Consequently, the question of whether an insolvent issue can be arbitrated under English law hinges on whether the dispute pertains to third party rights or a public interest issue. Non-arbitrable matters these include winding up of company, issuing payment orders, determining schedule of claims, setting aside transactions involving third parties. Liquidators' statutory powers exercised by the collective benefit of creditors cannot be displaced by prior agreements. अगर ये हो जाए तो हम सभी backdated agreement के expert हैं यहाँ, we can do it. That is the case in the UK. Now coming to the USA, in the United States, the arbitrability of bankruptcy related disputes hinges on the distinction between core and non-core proceeding under US bankruptcy code. Core proceedings involve rights that exercise exclusively under federal bankruptcy law. Section 157 clause B within bracket 2 of Title 28 of the US Code offers a non-exhaustive list of core proceedings. Courts conduct a fact-finding specific inquiry to classify disputes. The court allows limited discretion in core cases. So in Hayes and Company versus Merrill Lynch, the court also held that non-core matters must be arbitrated unless arbitration directly conflicts with the bankruptcy law. So, under the pro-arbitration policy of Federal Arbitration Act, non-core claims, particularly those arising in international context, are typically compelled to arbitration. So with all these, there are so many citations. I can only tell you that kindly as company secretary, you were doing one of the best. I have seen you in the benches both in NCLT and NCLAT. You were performing one of the best. Please get yourself equipped with the capacity with Mr. Sukla and team is doing it for you. So kindly prepare yourself well so that as soon as this process, because this is being considered even under IBC, I think exhaustively, so it will help you. With these words, I wish all the best to all of you. Thank you. Jai ICI, Jai Bharat.
Thank you very much, sir. As you said, not only at the admission stage, but also at the existing disputes, the company secretaries plays vital role as arbitrators. Now I invite our former president, multifaceted personality, very thorough professional, Nisar Ahmad sir, to address the members.
Namaskar. Let me at the outset convey my greetings to each one of us sitting here and those who have been virtually attended to or those who are not there. A happy PCS day. Very important day for us. 15th June is a happy PCS day and we must cherish and recognize the wisdom that we have initiated way back when I was passing, I was in the final and I did my CS and that a kind of joy we had in my memory along with our Bipin Bhai, late Bipin Bhai, Israni Sahab and all couple of on 15th of June when we got this recognition notified in the Gazette where a company secretary profession has been recognized as a professional institutions. Reason is, though it was there in 5th of August, October, 8th of October 1968, but this profession, because the independent profession as a practicing side of the profession, that was recognized for the first time and much water has so far flown into Ganges and now today we have been having a full bouquet of kind of professional integrity and professional work. I'm sure many more things to happen. It is not the end, it is a beginning and many more recognition to come to the profession of company secretary in practice side of the profession because earlier it was considered to be the employment oriented organization. The company secretary passing out and then getting it employment. But 15th June 1988 is the day, they can't forget that and today is the 15th June, so it is a very, very big thing. Each one of it to be greet and it was to be, it's a happy PCS day. Once again, convey my greetings to all of you. Now coming to the issue of what so far being now traveled down, we have seen Mr. Arora, Avneet has mentioned about the macro concept of what Mediation and Conciliation Act as well as the arbitration law from the ministry perspective, how this happened. I tell you one thing, if someone is interested in doing alternate dispute resolution work, the better and immediate requirement is to go through the Mediation Act 2023. Very soon, this year, hopefully, we are expecting it to roll out or professionalize. We have been discussing offline with the people, those who have been associated with to come out with IBC came into and then IBBI came into. Limitarily that institutions to be having an institutional framework. Work is already going on. Hopefully with the present law minister, I discussed this with Mr. Meghwal and he says we are keen to have it done this year itself. Once it is coming to, I tell you why I am referring to, because the litigation, if you see the national grid litigation, the data, 64,000 cases are pending in Supreme Court. 1,37,000 are there in the high courts. 10 lakhs around there in this district courts. 10 crores litigations we have now having in the district courts. Now this means that this opportunity, and then after this judgment of Section 89 was invoked in 2010 in some judgment, and particularly I would like those who are really interested in this venturing it in this area as an independent professional, along with appearances before the National Company Law Tribunal and Appellate Tribunal, to which the institute has been consistently now doing so, its endeavor to bring it, at par with legal fraternity. And many more our members have started now, Mr. Dr. Ashok has mentioned, many more our members have started now coming before the quasi-judicial body called NCLT and CLAT and arguing the matters very well. Now in this direction, Guwahati is also having a tribunal. The bench is there. 15 benches are already been working, out of which Guwahati is also there. So we have to gear up. Once it is there, this is the opportunity for both. You can be arbitrator arguing the case, you can be drafting the arbitration agreement. And therefore I must say, 2 judgments, very recent judgment here, that one had gone on 13th of May, just a month back. 13th of May, one judgment came in the Edcon matters. That has given a reference of 2024 judgment of 3 bench led by the then Chief Justice, SBI General Insurance. Now what I am referring to is 2 judgments require that how much the institution called Supreme Court, Honorable Supreme Court and High Courts are looking at the alternate dispute resolution to have a kind of process. Taking a clue from that, a mention was made by Venkat that institute has already started gearing it up, and a Section 8 company has already been formed in 2023, and thereafter institutions have started functioning. But the pace with which we are thought of, because I am also part of in the governing board of International ADR Center, and this year we are expecting it to roll out the center to start with Noida, and then to go to immediately, it's all simultaneously, to set up a mechanism in Hyderabad as well as that of our Bombay CCGRT to start with. Through 3 institutions, this is the plan, and we are meeting in the month of July, next month, because Justice Sadasivam, Honorable Chief Justice, is now expected to be in Delhi on 8th or 9th and 10th, 3 days. Hopefully we can discuss and maybe half a day or so. We have spent some time to create a kind of atmosphere, because rules are in the place. Already, institute has already come out with the empanelment of the arbitrators. So this is the next level of empanelment. The only requirement here is to start rolling out kind of thing, secretariat support, some support which we've been having. So the institute is already there. The kind of work you are expecting, you can't even imagine. Today somebody was taking open house, rule 8A, section 8A and so on, so form, etc. Certification and so on and so. With the invent of AI, 80% work what you have been perceiving, conceiving and doing are going to be done away with. Let us take it as institutions. I have been 2006 onward, I have been telling whole my body members, please come out from the not a small things. 80% time we have been spending in compliances, regulatory interface and so on and so forth. But we are not contemplating how to mitigate the discussions and litigations. Not to have a litigation at all per se. Why litigation is required at all? Because litigation is a very, very costly affair. So alternate area is now there, and I am very happy that institute has now chosen it to have a discussions in the third technical session. On the whole third technical session is devolved to have it alternate dispute resolution mechanism. Arbitration is of course there. The Supreme Court has also mentioned in one particular judgment to say that less than 10 crores rupees litigation cost, go mandatory send it to a mediation, and beyond that is go for arbitration. Some sort of things are happening. So it was a thinking. So I am just expecting these institutions to grow, and as a member of this body, we must start thinking from today onward, at least if those who are not there into this arena, must start thinking in this direction to start representation services, both before the quasi-judicial body called NCLT and CLAT, as well as that of the mediation and arbitration process. With this all, I must compliment and congratulate each one of you on the PCS day, and thanks to Institute, President and the Council for this opportunity given to me. Thank you so very much, and then we have some questions.
Thank you very much, sir. Hitting the importance of the ADR center. Whoever company secretaries are here in the handling the legal departments of the companies, and also who are advising on legal perspective, The institutional arbitration normally will be claused in the commercial agreements. So if you can refer the name of ADR center, our ICSI ADR center, as a institutional arbitration center in the arbitration proceedings in the agreements, commercial agreements of your companies, that will help this institution to grow forward. Thank you very much. Now I request Advocate Majid Madam, Executive Director, Asia Pacific Center for Arbitration and Mediation Center, and she is a author for the mediation publication, and also she is a standing counsel of central government. And I request her to come forward and give her address.
Greeting of the day to everyone present off the dais and on the dais. So before I begin, I would like to tell you my relationship with ICSI. So I am teaching in PMQ in every semester. I am there in evaluation also. And recently the Noida Center, which has been in Sector 62. So I am regular visitor there, and I am working for the promotion of that center as well. So the arbitration rules I have vetted. I have now handed over the mediation rules also. And the mediation publication, which has been released recently in Bombay, I think, in Mumbai. So that was also authored by me. So this is my relation with the ICSI, and recently I have been to Ahmedabad as well, and there I addressed the company secretaries in Ahmedabad as well. So this is my relation with all of you. And coming to the ODR, now the topic which has been given to me is the ODR. After you have heard from different panelists about the arbitration, so I'll be telling you about the practice, that how you can implement this in your practice and how you can make use of ODR or arbitration or mediation. Suppose if we are saying ODR, you have to understand that now we are in the world where the people are more on online platforms. So the traditional, if you see the banking or so, nobody want to go in the banks and stand in the queue, but now you have on one click you can transfer money, you can receive money, you can go for the loan, you can do anything. That is how now we want the access to justice should be one click away, and that is possible only through integration of technology, that is called ODR. So ODR is not a different kind of mechanism to handle your dispute or to resolve the dispute, but it is a different ways of handling arbitration and mediation. So now if you see, there are 83% of our population has internet access, and 77% use smartphone or computers daily, and 85% of population in India under the age of 50. That means we have to cater this 85%. Our users and our client and our the people who will be in our favor will be 85%, and those 85% will use only online platforms. So why not the access to justice should be customized in that manner, so that those 85 people find it very attractive. So before that, I would like to tell you that there is a difference between the online hearing or the virtual hearing and the online platform. So what does it mean when we talk about online platform? It is very important for us to understand what is ODR. Sometimes what happens, people, they are having a misconception. They feel that the ODR is nothing but having a virtual setting for the arbitration and mediation. क्या होता है हमारे यहाँ कोर्ट में, कोर्ट से अपॉइंटमेंट होता है आर्बिट्रेटर का, आर्बिट्रेटर के साथ सेटिंग होती है, उसके बाद में आर्बिट्रेटर अपना डिस्क्लोजर देता है, एंड फर्स्ट मीटिंग होती है, मीटिंग के बाद वो कहता है अब हम ऑनलाइन हियरिंग करेंगे. Many people, they are having this conception that this is what you call ODR. So this is not ODR. ODR is there where you don't need human intervention. This is a secured and protected platforms, dedicated platforms from where you will be having you can start invocation of negotiation, mediation and arbitration and publication of the award through this platform only. You don't need any human intervention other than the person who will be appointed as an arbitrator or mediator who will be sitting there. So आपकी पूरी arbitration वहीं पर होगा, आपकी meetings वहीं पर होंगी, उसी के server पे होंगी, it will be safe, secured and protected. So this is what the called ODR. So ODR is not virtual setting, virtual hearing. It is a dedicated platform which we have to understand. Now we need to understand that suppose if there is a dedicated platform, how many platforms do we have in India? Such kind of platform. So recently we have come up with such platform, that is PeaceGate app. You can see it www.peacegate.in. So these kind of dedicated platforms are very, very necessary and very important to give momentum to this ODR practice. Otherwise, this ODR practice, whether it is mentioned in Act or not mentioned in the Act, it is useless, because it will be again integration of virtual setting into the normal setting. So dedicated platform which will be used for the ODR. So now the thing is that if those are the dedicated platform, what are the benefit of those ODR arbitrations or mediations? So whatever the documents which will be uploaded, there will be a separate dashboard for each and every participants, parties, lawyers, and also the arbitrator, and that will be encrypted. No document can be accessed by another person. So it will be your dashboard, your document, you can access any point of time. It is not e-filing. E-filing or emailing, it is different, but in ODR it will be dedicated document can be uploaded by those party, accessed by anyone, and notification will go to another person that now this person has filed this document. आपको नोटिफिकेशन आ जाएगा, नोटिफिकेशन के बेस पे आर्बिट्रेटर बिना पार्टी की मौजूदगी के वहाँ पर एक अपना प्रोसीजरल ऑर्डर बना देगा. सो दिस इज व्हाट द काइंड ऑफ प्लेटफॉर्म वी आर थिंकिंग. एंड ना तो उसकी रिकॉर्डिंग हो सकती है, ना उसका उससे कुछ चीज़ डाउनलोड हो सकती है, ना ही उसके फोटो क्लिक हो सकते हैं. So these are the data privacy which could secure the entire arbitration and mediation on that platform. So now the thing is that if suppose we have those kind of platform, then what are the opportunities for the CS? आप लोगों के लिए वहाँ पर opportunity क्या है? अब आपको आर्बिट्रेशन पता हो गया, आपको मीडिएशन पता हो गया, आपको ये भी पता होगा कि आप कितनी जगह पे आर्बिट्रेटर मीडिएटर हो सकते हैं. लेकिन आप इस टेक्नोलॉजी का इंटीग्रेशन के साथ यूज़ कैसे करेंगे? हाउ यू विल यूज़ ODR एंड हाउ यू कैन बी इनटू ODR प्लेटफॉर्म्स. तो पहली बात तो ये है कि आप लोगों को आइडेंटिफाई करने पड़ेंगे कि कौन कौन से ODR प्लेटफॉर्म इंडिया में एग्जिस्ट करते हैं. अगर कोई भी प्लेटफॉर्म में ह्यूमन इंटरवेंशन है तो वो ODR प्लेटफॉर्म नहीं है, दैट इज़ द कॉम्बिनेशन ऑफ वर्चुअल एंड फिजिकल सेटिंग. तो वो कंप्लीट डेडिकेटेड प्लेटफॉर्म नहीं है. देयर विल बी अ कॉम्प्रोमाइज विद द डेटा प्राइवेसी, विद द प्राइवेसी एंड डेटाज. सो दैट इज नॉट ऑथेंटिक. तो अनदर थिंग इज what opportunity you have being a you know CS there. So let me be very honest to you. हम लोगों के पास ना, now we are talking about the smart contracts. Everything is coming smart. So why you people are not getting smarter? Because if you see, this is one traditional way of doing your work, what you people are doing. But integration का ज़माना है. अब आप अब तक integrate नहीं करेंगे, you will not reach to the places. Somebody asked just now in the open क्या था ये house, हाँ, open house में कि हम दुबई में कैसे कर सकते हैं, हम वहाँ कैसे कर सकते हैं. आप यहाँ बैठे ODR के थ्रू आप कुछ नहीं करें, लेकिन आप आर्बिट्रेटर ज़रूर हो सकते हैं. You can do all these things, but the only thing is you need to identify the venues कि हम वो करें कैसे. तो मैं कितने सारे कंपनी सेक्रेटरीज को ट्रेन किया है, उनको इंटरनेशनली दे आर इंटरनेशनली नाउ इम्पैनल्ड. सो द मोस्ट इंपॉर्टेंट थिंग इज यू हैव टू आइडेंटिफाई दैट वेयर यू कैन गेट इम्पैनलमेंट. इट इज़ नॉट जस्ट अ ट्रेनिंग. सो द ट्रेनिंग तो आप कहीं भी कर सकते हैं, बट हाउ यू विल गेट इम्पैनलमेंट. So that is something which is very, very important, because I am from a center, I administer arbitration and mediation. I know how many company secretaries are there impaneled with our institution, not only in India but 10 countries across. And also there is one company secretary, Mr. Jayan. He is from Cochin. I do not know how many of you will be knowing each other or not. He is teaching in our center, arbitration. So that is how you have lot of opportunities. If time permits, I will be telling you in my questions that how you can do the trainings, how you can enhance your capacity building, how you can be impaneled, or how you can make money. पैसा बहुत है इसमें, बहुत कम टाइम में बहुत ज़्यादा पैसा है. So how you can make additional money also. So right now what you have to do is, suppose if you now you know the SEBI and RBI, they are talking about the smart portal. So if suppose those smart portals, they also have a provision for having a for empanelment for the online neutrals. So you can be online neutrals, you can be neutrals in, you can be there for the ODR clauses also. Like just now Mr. Our beloved moderator, he just mentioned about the clauses. So the arbitration clauses is something which is the part of the main contract, and you being a company secretary know in and out about any company also. So आप वहाँ पर क्या कर सकते हैं, बड़े आराम के साथ आप एक ODR प्लेटफॉर्म को आप मेंशन कर सकते हैं कि कल को कोई डिस्प्यूट होती है तो दिस प्लेटफॉर्म पे होके जाएगी. जैसे कि सेबीज एंड ऑल, दे आर ऑटोमाइजिंग देयर डिस्प्यूट एंड दे विल बी सेइंग दैट नाउ वी विल बी हैविंग अ पोर्टल, स्मार्ट पोर्टल, जहाँ पर कि ऑटोमेटिक हमारी डिस्प्यूट ऑनलाइन पोर्टल के साथ रिजॉल्व होंगी. सो दैट शुड बी द वे एंड दिस इज द फ्यूचर. And with this now, I would like to just say one or two things where you can have an opportunity. One is you can be a consultant not only in domestic arbitration but also international arbitration, and you can provide them, suggest them the ODR platform. Asynchronous arbitration हो रहे हैं different time zone में, कोई US में बैठा है, कोई कहीं और बैठा है और arbitration चल रहे हैं. Because of this platform, filing is very easy, everything is very easy. So that you can do is you can be an arbitrator and mediator in so many places. Even in NALSA, just now I was talking with Mr. Moderator. So there is in NALSA also you have an opportunity to become a mediator. There is an opportunity. So you can do that as well. And in MSME and cross-border justice also you can be the one who can integrate the technology and use of ODR there as well. And the most problem in the last I would like to say the problem arises जब आप आर्बिट्रेशन अवार्ड रेंडर करते हैं और आपको प्रोसेस के बारे में इशू होता है. सब्सटेंस पे आर्बिट्रल अवार्ड कभी सेटिसाइड नहीं होता. अगर आप कोर्ट में देखें तो आर्बिट्रल अवार्ड इज सेटिसाइड मोस्टली ऑन द प्रोसीजरल इम्पेडिमेंट्स और प्रोसीजरल लैकिंग. सो दीज ODR प्लेटफॉर्म विल टेक केयर ऑफ दोज प्रोसीजरल डिफेक्ट्स ऑल्सो. आप प्रोसीजरली कोई चीज़ गलत कर ही नहीं सकते. सो दैट मीन्स दिस प्लेटफॉर्म विल गाइड यू टू डू आर्बिट्रेशन प्रोसीजरली करेक्ट. तो वहाँ पे कोई इशू ही नहीं है. फिर सब्सटेंटिव पार्ट पे तो आप लोग खुद एक्सपर्ट हैं, सब्जेक्ट एक्सपर्ट, तो आप लोग कर सकते हैं. सो थिंक अबाउट इट दैट हाउ यू कैन इंटीग्रेट arbitration and mediation either with technology or without technology and can become a smart CS. Thank you so much.
Thank you very much, madam. Now I request Mr. Chirag Balyan, Assistant Professor of Law, Maharashtra Law University, to come forward and address.
हेलो, अ वेरी गुड आफ्टरनून. आप सबको नमस्कार. सबसे पहले मैं आप सब लोगों को धन्यवाद करना चाहूँगा कि आप पेशेंस से बैठे हैं. 12:40 हो गए हैं. मैं समय की नज़ाकत भी समझता हूँ कि कुछ लोगों को भूख भी लगनी शुरू हुई होगी. कुछ लोग अपना बैग भी टाइट पकड़ के बैठे हैं कि किस सेकंड में मौका देख के चला जाए. बट स्टिल आई होप that whatever time you have waited, you will find worth after listening to me. I will start from the beginning. We use the word arbitration and mediation together as if they are Romeo and Juliet. We put them under the umbrella of ADR. But to be very true, they are not Romeo Juliet. They are not even brother sisters. They are envy neighbors. Arbitration, to be very true, is not even an ADR. Because there is no alternative to arbitration, especially if it is international arbitration. You can go to court. In case of domestic arbitration, you can choose between domestic arbitration and court. You always have that choice. But where do you go in case of international arbitration? Where do you go? There are no international courts. There is this very interesting paper by Professor Jan Paulson, wherein he said, sea elephant is not an elephant. Like sea elephant is not an elephant, international arbitration is not arbitration, because there is no alternative to arbitration. There is no alternative to international arbitration. It is the default choice. That's what you have to do, and that's what the government is pushing when they are saying we want to make India as a global hub of arbitration. Primarily, they are indicating at international arbitration because they want to focus on enforcement of contracts, they want to focus on ease of doing business, and they want to focus on increasing FDI flows. So the idea is, how does arbitration contribute to the economy? As far as alternative of arbitration to the court is concerned, the only reason is pendency. Move my work from my table to the other table. Probably other table will do it faster. We don't know if at all. Under Constitution, we have a right to approach court, we have right to access justice, and if we have a right to access justice, does arbitrator give you justice? Albeit private justice. We need to think about it. Now, let me come to the threefold role of the company secretaries in so-called ADR or arbitration and mediation. I'll primarily focus on arbitration. One is prevention, second is strategic, and third is dispute resolution. Now, the general thing which I am listening, because as Iram mentioned, I am also continuously engaging PMQ lectures for many of you. The general thing is make us arbitrators. Fine, become an arbitrator, become a mediator. But remember your motto, good corporate governance. Good corporate governance means you have to advise your board in certain matters. You have to do contract management. You have to do due diligence. Are you drafting arbitration agreements in a right way? Are you thinking if arbitration agreement should be included in your contract or not? And what happens when you don't think about them? I'll discuss two cases here. One is the case between Kotak and Indus Biotech. Kotak invested certain money in Indus Biotech through OCRPS. Now Kotak wanted to redeem certain amount. Indus Biotech refused. Kotak went to NCLT, Indus Biotech went to arbitration. Now the question before NCLT was, should we do insolvency, should we do arbitration? There is a shareholder agreement which has an arbitration agreement. Now as CS, how many of you say that shareholder agreement should have an arbitration agreement? Should we have? Yes? You may have. You may have. Because this is a dispute pertaining to OCRPS, NCLT can also refer the parties to arbitration if it comes to the conclusion that there is no default within the meaning of insolvency law. But what if it would have turned out to be oppression and mismanagement claim? Your arbitration agreement will fail. But what if one of the parties is Singapore and seat is Singapore? Your arbitration will succeed, because the oppression and mismanagement claims can succeed in Singapore through arbitration but not in India. So there are so many variables. Where are you doing arbitration? Is it international arbitration? Is it domestic arbitration? And what kind of dispute will emerge in future? And that's why I said preventive, strategic and due diligence. Are you thinking about arbitration in this way? And if you do not, it results into dispute. You include a clause of third party funding in your arbitration agreement, and then the question arises, should it be enforced in Indian courts? Does Indian courts recognize third party funding? Are we thinking about it? Are we brainstorming about it as company secretaries? Once we start brainstorming about it, we contribute to the vision of good corporate governance. Take the other example of a dispute between Indian Oil and SR, now acquired by ArcelorMittal. Indian Oil had a claim of $450 million US. SR told Indian Oil, there are other creditors also, they have instituted insolvency. So we cannot have arbitration. Indian Oil participated in the insolvency process. Resolution professional admitted the claim only at the nominal value of 1 rupee. So $450 million, 1 rupee, so that they could participate, they could vote. Nothing else. Plan got approved, COC approved, NCLT approved, Indian Oil never got paid. Now ArcelorMittal has taken over it as per restructuring it. Can it sue ArcelorMittal? Supreme Court said no, there is clean set doctrine. But instead of restructuring, what if this would have been acquisition of this SR by ArcelorMittal? Then there is something called as assignment of rights, and even arbitration could be assigned. Now you don't know. Now, should we have insolvency? Should we have restructuring? Why there shouldn't be, before there is a restructuring in case of debt, why there shouldn't be an attempt at the corporate level to get it acquired, to, you know, do it internally by yourself rather than going to the IBBI machinery. Because then that takes away the right of one of the creditors. Right? So that's also something we need to thought about. Now consider, instead of Indian Oil, this would have been British Petroleum and the seat would have been London. Now English court would have applied English law, and under English law, even if there is an insolvency claim, dispute could be arbitrated. Now unless you train yourself to these niceties, you cannot adequately prevent, strategize and due diligence. And then thirdly comes the role of you as an arbitrator, you as a mediator, you actually resolving the disputes. And I think your primarily role comes for the disputes under shareholder agreement. Now if you are drafting article of association, you are vetting article of association, consider if you should have arbitration agreement or not. Shareholder disputes can be arbitrated, and who knows, understand shareholder agreement better than company secretaries, who understand AOA better than company secretary. So it's not every kind of arbitration you have to do, you have to think what suits your expertise. Insolvency maybe, but definitely shareholder agreement. Now if you are a corporate legal advisor, should you advise your corporation to include that arbitration agreement? Again, do you anticipate operation and mismanagement claim which may never be arbitrated, or would it be just about redemption of share, equity share, preferential share, all those issues? Yes, they could be arbitrated. NCLT has the power to appoint an arbitrator in those kind of cases. So yes, you definitely have an opportunity. As Iram rightly pointed out, you can make mad money through ODR, because much of this arbitration you could also do through online platforms. And thus, there are three things you require if you want to succeed in this career, whether at the preventive level, strategic level or execution level, which is training with an authentic institution, accreditation with institution like CR, Chartered Institute of Arbitrators, Singapore Institute of Arbitrators, or once we have our own Arbitration Council of India, which also has a mandate of training, or Mediation Council of India, and finally empanelment. You need to get empaneled, start slow, start with ICSI, and then go bigger. Thank you so much for listening. I wish you all the best.
Thank you very much, sir, for your address, and especially the empanelment. Friends, on this occasion, I would like to state that Assam's Guwahati High Court has made empaneled list of arbitrators and technical experts also, who are registered valuers and all. They can go and apply themselves for the empanelment. Now we will start with the question answers with the panelists.
Let me tell you that each of the panelists will get only one question to answer. If time permits, we will go for the second question. The first question to CS Avneet Singh ji. Despite significant advancements in ADR landscape, there are ongoing concerns regarding lack of a strong arbitration culture, inadequate infrastructure and necessity for improved legislative support. What further actions are being contemplated by the government considering these concerns, please?
Thank you for the question. I think जो हम लोग सुबह भी बात कर रहे थे prior to the question answer session, the focus or India has had a culture of ad hoc arbitrations. Ad hoc arbitrations में what happens is there is no supervision of the institution, and if there is no supervision of the institution, it continues to happen in the manner the arbitrator wants to do it. So from that, the focus has now shifted to doing arbitration is in an institutional manner. If we go globally possibly 95% of arbitrations are done through institutions, and maybe 5% is ad hoc, which is the other way around in our country. So the focus after 2019 has been to ensure that all legislative and policy support is given so that arbitrations now happen through institutions. And as I was saying, it's a great initiative by ICSI also to set up a center. Similar to that, I think now that the center has been set up for arbitration, or as it's called ADR, even mediation can be taken up by this center at the first instance, and you can have the head start, because once the Mediation Act is enforced in the entirety, you will always have the system ready to let it go up and running. So that is one of the steps which can possibly improve the ecosystem. That apart, legislatively also a lot of steps are being taken. As I was telling, in the last 11 years, the amendments to the Act have happened thrice. And we are also envisaging one more amendment for which public consultation is already over. So consistently an attempt is being made to ensure that legislation is up to the mark with global benchmarks, and it also suits the requirements of our country, because we are a large country, we are a diverse country. So we cannot possibly lift up best practices of Singapore and UK and put it in our act. So there is a conscious decision on the part of the government to ensure that the global benchmarks are also tailored made to our requirements. So that has been a consistent effort to then see that the entire ecosystem, legislative, policy, practice undergoes a change to suit the requirements of the stakeholders.
Thank you, sir. Venkat?
Yeah, this is question to Advocate Manu Manjim, Madam. Do you think ODR required a separate law, or a conventional law will take care of the protection and other things?
So, so far what we have in arbitration, there is no mention about ODR. And if we see mediation, there is mention about ODR. So we have mention about ODR that the online mediations can be conducted in under mediation law. But see, whenever there is the process which will happen on ODR that required data protection, that required privacy, that required confidentiality, and the parties may not be having trust on ODR because they feel that how their documents, their discussions and their meetings will be secured. So that is the problem which we do not have so far. So what I feel is Arbitration Council of India and the Mediation Council of India will come up with the regulations and the protocols and the guidelines to conduct ODR. I think, Mr. Ravneet, am I right? So that is in the pipeline, because I was in the committee which was made by the Ministry of Law and Justice for making rules on the Mediation Act. So I have assisted that committee, and there we have discussed that on ODR, we should have a complete code and complete guidelines that how to conduct ODR this. So I don't think as this state we need in India, we need any separate law, but yes, convention we can think of because of the enforcement of international awards. So whereby, if you sign, there is a problem now which is happening in the United Nations Working Group 2. The paper is now getting ready on the enforcement of electronic award, and whereby the problem which we are facing is that they have said that the signature which is been on the award is something which needs to be checked by the country where it is come for the enforcement. So that is something which is under the thing, and we feel that there could be a convention on the digital signature which can be having a uniformity, or either that can be an addition to the New York Convention, something. So that is underway, sir.
Thank you.
Next question to CS Nisar Ahmed, sir. How can we encourage businesses and companies to adopt ADR mechanism in their contracts and dispute resolution strategies? How can successfully case studies of ADR be utilized to demonstrate its effectiveness and encourage its adoption, please?
Thank you very much for this question. Before I go into the answering your question, I would like to have one more statement to make that what International ADR Center of the Institute has already been finalized and circulated to all our members. Those who are viewing us through virtual mode or those who are there in the physical mode must take it forward yesterday also we discussed about the dissemination of this particular the contract agreement and draft clauses. But Mr. Narasimhan was the president in the previous year, and we have finalized and has been circulated. And I am sure everybody must have got it. Let the institute to start with on continuous basis to say those who are in the employment, those who are in practice, they must start adopting the standard clauses for drafting of any contracts, contract management issues. If you can add the standard very good templates, it would be giving a very good result to the International ADR Center, which Institute is embarking upon. So that is the appeal particularly to all by. The second, my observation is Guwahati is functioning as a, NCLT is there. I happen to be the task force chairman of the National Task Force. I am appealing to all the members from Guwahati or Northeast region to take advantage of appearing before the NCLT bench because the president of the NCLT has been now making a mention that company secretaries are not coming forth before the Guwahati bench. So my request would be, since we are sitting in Guwahati and though there was no specific things, as a chairman of task force, it's my appeal to all of you to please join hands and start appearing before the NCLT under 251, 252 matters, 230, 232 matters, etc., etc. Now, the answering to this question, this, as I mentioned, this ADR is very rapidly evolving field, especially within the corporate sector, where companies often enter into various business relations and agreements, and the institute to encourage through its members in the adoption of ADR, alternate dispute, by highlighting the time and efficiency, cost efficiency, very important part. But two part, because litigation is a modality of litigation as mentioned in the opening part, that we have around 44 lakhs cases in the high courts. I'm sorry, at that time mentioned something different. And lower courts is having 1 crore 9 lakhs cases. This is a pendency. Now look at this, in this scenario, after this dissemination or after this implementation of Mediation Act and the Arbitration Amendment, which is already 2024, what Mr. Arora mentioned, it's going to be a very, very robust kind of thing. My experience of dealing for 5 years for NSE, BSE in northern region, modality of any dispute is only taking 3 months maximum. 3-4 hearings and that's all. And pleadings completed and then 2-3 hearings and then conclude. Pass an order. If they are not interested, go 34 appeal to High Court. But 90%, my experience is, my 5 years association with them earlier, that 90% of the case gets settled and all the parties are now settling together. They are not going to prefer an appeal, 34 appeal before the High Court. So that's a very important part. Promoting the confidentiality is another part which we have to propagate in the encouraging the business one. Emphasizing pre-litigation kind of dispute resolution which is faster and less adversarial. These are the points which I thought of picking at things, answering to your questions. Thank you very much.
Yeah, this question is for Mr. Chirag. Sir, you have mentioned about international arbitration. Now the question is, the Draft Arbitration and Conciliation Amendment Bill 2024 proposes a bifurcation in the definition of the court for domestic and international arbitration. How will this change and affect the jurisdictional clarity and efficiency of arbitration proceedings in India?
In order to answer this question, first we need to understand what is international arbitration. International arbitration, as we understand in Indian context, is very different from how it is perceived in UNCITRAL. We are an UNCITRAL compliant country, but not on the definition of international arbitration. For us, international arbitration means there should be foreign national, foreign company, foreign entity. That would be called as an international arbitration. Now, generally speaking, the emphasis in international arbitration is neutrality. I am a Malaysian party, you are an Indian party. You won't agree on Malaysia as a seat, I will not agree on India as a seat. We will choose Singapore as a seat. Because what we want court of the neutral country to be the arbiter in case a dispute arises. So the central focus of international arbitration is neutrality. And that's why usually it's a broader negotiation. They would say if the substantive law which will resolve the dispute would be of India, then let's say the choice of seat would be as per us. Let us make that call. So there is some kind of balance of power in that scenario. So first of all, we need to understand the dynamics behind choosing, why we choose international arbitration and why we choose a particular seat, whatever we choose. Now coming to the question, the definition of court. In order to understand the definition of court, we need to go back to the genesis from the case of Bhatia International, Balco, 2015 amendment and now. Let's be very clear. Generally speaking, when it is a foreign seated arbitration, Indian courts do not have any business. Bhatia judgment said we do have a business. Balco judgment said we do not have a business. 2015 amendment said we do have a business only for two purposes. Section 9 interim relief, section 27 assistance of court. Third, if you still want section 9 and 27 to go away, enter into an express agreement that you don't want part 1 to apply. Otherwise, default mode is even in international seated arbitration, two sections will apply. That's 2015 amendment. That's where we stood prior to proposed 2024. Wherein now we are saying that if it is domestic arbitration, it will go to your district court, and if it is an international arbitration, it will go to the High Court. That's the simple distinction. The idea is the kind of expertise which is debatable, available at the High Court. High Court probably would be well suited to determine section 9 application. If at all section 11 application is also coming, or section 8 anti-suit injunctions, anti-arbitration injunction, there are a number of applications which might come to Indian court. So the idea is Indian courts will be better suited. So understanding from this hierarchy, from this chronology, that's the significance of this proposed amendment.
I will tell you one example. Basically, when I was Director Finance and CFO in Hindustan Aeronautics, Bangalore, one day what has happened, because after attending Russian meeting, I had just gone back to my son USA. After returning to India, then I have gone. So I was in US. I didn't have any book, any paper from the HAL side. Suddenly, Defense Secretary called me, Misra, you come to Moscow, I am also coming to Moscow. Embassy will send you all ticket, every arrangement, but you have to be there. And then I told I don't have any detail and I don't have any experience in international, how we will sort out this international dispute. And I was not matured because I have not worked in at that time NCLT or NCLAT. In any case, it was a direction I went. I only asked my son, can you take me to Harvard? Slightly I will see their library, then I will find out how to sort out this. So there was an American case, I have forgotten that name. It was mentioned whenever there is a dispute between the two friendly country, the best way is to sort out on table. That they have provided a procedure. I asked Harvard, that library fellow, because like India, we will always go with some money to make photocopy. That fellow smiled and he gave me the photocopy, all the photocopy what I wanted, 3-4 pages. With that page, when I was in Russia, from the Russian government side, their Minister for Defense, State Minister for Defense was there, and from our side, Defense Secretary and myself was there. Because my chairman, he was puzzled, he didn't attended that. So then at that time, interpreter was there to explain. Then we told we are friendly, listen. It was a matter of closing one joint venture company. It was not working effectively. So you know, Russian side, both sides, they will tell in their language, you will explain, tell in English, so it takes time. So we gave, material fact was given by both the sides. Thereafter we told, it is better we must close by today evening. Russian side, first they discussed among themselves, then they told, okay. Now that issue, then they gave some figure that this much amount and India side will have to pay and Russia side, all those things. Then I told, if we refer this matter either to arbitration or we go to, as usual, the international court, what we will get? Our TADA bill itself will be more than this amount. Then that fellow, their finance man was also there, he calculated. Then he told it is better to discuss in the evening and sort out. So sometime I can tell you, table talk can sort out most of the issue. When I was in NCLT Bangalore, let me tell you openly, one case was there. Now IBC came recently, so that fellow was asking, he has asked for this money, at that time money was there, I didn't pay. Now he has brought this case against me. And I am prepared to pay him the amount, he is not taking the check. He is demanding from me 36%. Then my brother judge was very short-tempered judge. He told Mishra ji, how much maximum penalty I can fix? I told him, without reading any law, you fix the penalty as much as the principal amount is there. Because if the party, you are paying him the full amount, and the party is demanding for some 3 months' time 36%, forget about the law. It is a natural thing. So most of the law, I can tell you, or most of the thing, most of the dispute, as company secretary, I have seen you in appearing, always apply your first hand whatever your mind says. Law is virtually blind. Even if I have fixed that penalty amount, perhaps High Court may not have reduced much more than 50%. Thank you.
Floor is open only for one question. That will be from Ashish Mohanji, Secretary ICSI.
So, yeah, thank you. I just wanted to know from Mr. Chirag Balian, because during his address he pointed out one very specific, significant point, especially with regard to international commercial arbitration. You said that when the seat is some outside country, say UK or Singapore or any other country, and the matter is regarding insolvency or say operation and mismanagement, it is possible that arbitration proceedings can happen elsewhere, not in India. So when you said that India is looking for becoming an international arbitration center here, so don't you think then the most important thing is that there should be a policy intervention where arbitration proceedings can be opened for all these legal legislations? Otherwise, every time we will get under this trap. Just your observation, please.
Sir, we can't have a uniformity on this aspect. Indian law aligns with Singapore and many more countries. England is the departure, point one. Point two, India as a hub of international arbitration, we think we can do it by law. England is the hub of international arbitration. They are not UNCITRAL country. Paris is the hub, the originator of international arbitration, not UNCITRAL country. Singapore, recent hub, UNCITRAL country. India, UNCITRAL country. So why Paris is hub, London is hub, Singapore is hub? It is the culture. They have good universities which offer best of the world program. They don't just have Indian lawyers, they have transnational lawyers. Now we have opened the market to the foreign law firms. Singapore in their commercial court also has the foreign judges. So idea is what drives the trust of the foreign investor in Indian court? What drives the trust of the foreign investor in the enforcement of contracts in India? That's the pivotal factor. Rules in India are as good as any other country. What kind of good accreditation programs, and then coupled with the events which happened like a month back, wherein Indian Supreme Court retired judge was an arbitrator. His award went to Singapore, and it was set aside because of plagiarism. Now, these are also the factors which affects the legitimacy of the country in becoming hub. And most important, every country is a hub, and now I am canvassing for me. Every country which is a hub, the topmost arbitrators are academics. They are neither lawyer, they are no judges. They are technical people like CS engineers. If we keep the business only to lawyer and judges, that doesn't serve the purpose. We have Arbitration Bar of India, 26 lawyers. No academic, no CS, no technical person. Waste diversity. Unless you have diversity, how do you become hub? Take any leading name who is a leading arbitrator in the world and tell me that person is not an academic person or is not a technical person. Lawyer brings an adversarial mindset in the arbitration. Adversarial mindset is not good for arbitration, it's not good for mediation, and that's the biggest bottleneck for India. Thank you.
Just add a point to what has been said, because there was a point on policy intervention. So, as you have rightly pointed out, the seat of arbitration being outside India and the interplay with insolvency cannot be relatable, because insolvency is something which is judgment in rem, and whereas the offshoot or the response or the result of arbitration is something which is in persona. So even otherwise insolvency में तो arbitration हो भी नहीं सकती. जहाँ तक चिराग जी का point था on making India a hub of international commercial arbitration, a very valid point that possibly बाहर के देशों में क्या है, arbitration itself is taken as a profession. People don't do arbitration as a part-time job. हमारे यहाँ पे क्या है, जो हमारे वकील हैं या हमारे जो judges हैं या जो वो court hours के बाद arbitration करते हैं. So that is the biggest change which is required, apart from what we have been saying about moving from ad hoc to institutional. Again, the rule is कि संस्थागत arbitration होगी तो वो focused होगी, ad hoc होगी तो वो जैसा कहा गया कि जो अभी जो कर रहे हैं judges यहाँ वो continue करते रहेंगे. So 2 points possibly, more of formalization of the process along with making it a full-time.
Thank you, sir. Now I request C. Dwarkanath, sir, council member, to conclude this session by giving vote of thanks.
Thank you, Venkatramana. I would like to extend my heartfelt gratitude to our esteemed panelists for their valuable insights and expertise on the topic of this session, alternate dispute resolution. The panelists shed light on the current landscape of ADR in India, the challenges we must navigate, and immense potential ADR holds for the fast-track dispute resolution. The panelists have effectively articulated that the core objective of ADR mechanism is to elevate the judiciary workload and ensure swift and equitable justice for disputing parties. ADR mechanism also promotes amicable settlement, facilitate constructive outcomes, and help in preserving relationships as well. We examined how ADR provides companies with efficient and cost-effective ways to resolve disputes while protecting their reputation and ensuring compliance with legal frameworks. We discussed that a company's commitment to ADR enhances its integrity, reliability in the eyes of stakeholders by showcasing a proactive approach to the dispute management. The discussions also explored significant legislative reforms that have strengthened India's arbitration framework, including amendments to the Arbitration and Conciliation Act 1996, enactment of India International Arbitration Center Act 2019 and Mediation Act 2023, establishment of dedicated ADR centers and the ICSI International ADR Center, the upcoming Alternative Dispute Resolution Center in GIFT IFSC, and technology-driven solutions like online dispute resolution that are transforming India's approach to dispute resolution. These reforms are designed to enhance ADR framework and ensure a greater efficiency, accessibility, and affordability. Collectively, They mark a substantial progress towards fostering a more conducive dispute resolution ecosystem in India. We also discussed the vital role of company secretaries in India, emphasizing their expertise in corporate governance, legal compliance and negotiation as essential skills for fostering prompt and effective dispute resolution. By navigating complex regulatory frameworks and facilitating constructive dialogue, they can be instrumental in resolving corporate disputes and ensuring sustainable solutions. We also examined the need to continuously foster awareness and understanding of ADR among corporates and stakeholders, and discuss how showcasing successful case studies and promoting best practices can drive wider ADR adoption to strengthen its role in dispute resolution. To conclude, today's discussions have underscored the critical importance of establishing a robust and effective ADR ecosystem as a strategic necessity for India's economic and legal landscape. By investing in training and capacity building programs for the professionals involved in ADR, we can cultivate a new generation of skilled practitioners who are adept at navigating complex disputes. Thank you for the esteemed panelists for sharing their valuable expertise and championing a culture of amicable dispute resolution through ADR. Your insights have not only enriched our understanding but also have inspired us to actively engage in fostering a more collaborative approach to the resolving disputes. Thank you very much.
Thank you, sir, for your wonderful words. As we approach the concluding moments of the session, it is my honor and privilege to express our heartfelt appreciation to the dignitaries who have graced us with their valuable presence, time, and insights. To mark this occasion, we would now like to present mementos to our esteemed guests. I now request CS Amit Parekh, past chairman, Guwahati chapter, to please come on the dais and present a memento to our learned panelist, CS Avneet Singh Arora. Mr. Amit Parekh. Please put your hands together. I now request CS Praveen Chached, past chairman, CS Pankaj Jain, to please join us on the dais to present a memento to our esteemed panelist, Dr. Ashok Kumar Mishra, council member and government nominee. Thank you, sir, for your precious time. Please put your hands together. Thank you, sir. I now request CS Bimal Devnath, past chairman, CS Narayan Sharma, past chairman, to please join us on the dais and present a memento to our learned panelist, CS Nisar Ahmed ji. तालियां बजा दीजिए प्लीज. I now request CS Rakesh Agarwala, CS Vishal Harlalka, Vice Chairman EIRC, to please join us on the dais and present a memento to our proficient panelist advocate Irram Majid. Thank you, ma'am, for gracing the occasion today and addressing the Please put your hands together, ladies and gentlemen. I now request CS Anush Saraswat ji, Chairman EIRC, to join us on the dais and present a memento to our proficient panelist Chirag Balyan ji. I now request C.S. Suresh Pandey to please join us on the dais to present the memento to Chirag Balyan ji. Please put your hands together, ladies and gentlemen. Thank you, Chirag ji, for coming and guiding us. Thank you, everyone. Your perspectives have truly expanded our understanding of ADR as a critical skill for governance professional. Thanks again to all our distinguished speakers for this enlightening session. Thank you so much. No, we have one, we have few releases after that. We'll have one group.